to be to my right.
All right. And if you had a chance to review the charging documents in these files with the client?
Have your honor, would waive formal reading at this time, enter a not guilty plea. I may have to follow up with some sort of forensic referral, especially considering the new case that was just filed in district court. And so we would ask to set this out for a docket call that March 17th date at the court could accommodate.
Okay, and so you want to reserve on any forensic center referral?
Yes.
We'll enter pleas of not guilty on his behalf in all three files. Reserve on forensic center referral. In the 7114, it looks like there was a bond issue that originated in the pre-bind over that's been sent up as well in only the 7114 file for an assaultive incident with his stepfather. Is that just set for the status conference on this then?
That makes sense.
Yes.
Okay. So on 7114, we'll continue that for a status conference on that contempt, same date and time. And then all three files, schedule this for docket call on March 17th at 10:30 in the morning. The parties did advise me there were new charges that were recently filed against Mr. Brown. And Ms. Goodrich, are you seeking anything on bond as a result of that or no?
Your Honor, at this time, due to the second time he's been charged with a new crime while incarcerated, I would ask for his bond to be revoked.
Mr. Nightingale, any thoughts on that?
No, not at this time, Judge. If the court wants to do that, I think the court's within their rights to do it at this point. If we want to review that in the future, we can certainly do that.
Okay. All right, in all three of these files then, I'll enter an order revoking Mr. Logan's bond or Mr. Brown's bond and remanding him to the custody of the sheriff till further order of the court. And that's, of course, without prejudice to you filing any appropriate motion at an appropriate time.
Thank you.
Okay, so Mr. Brown, I'm going to next see you on March 17th at 10:30 in the morning, all right? See you then.
Thank you.
Give you these orders. Then next I've got an arraignment of Carly Price, and she's appearing on Zoom. All right, Ms. Price, can you hear us?
Yes, Your Honor.
All right, this is People v. Carly Price. It's filed 25-7120FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Benton County Prosecutor.
No, and I go for Ms. Price, who appears remotely via Zoom.
All right, and Mr. Nightingale, have you had a chance to review the charging document? Mr. Fleming?
Have your honor would waive formal reading of charges and rights at this point, enter a not guilty plea on her behalf. No forensic center referral required for her. I think this would be a one-day trial. And I think if we set it on the 17th, we could probably resolve on that day.
Okay, well, under plea of not guilty as to the charges of, looks like a delivery of methamphetamine with a drug double, computer crime, a DWLS, and a habitual second notice. I think that does look like a straightforward enough case. We'll put that on our expedited docket so that the initial docket call will be a plea cutoff, motion cutoff. We'll schedule it for March 17th at 10:40 a.m. And Ms. Price, are you, she lives local?
She does not judge. She's in Otsego, I believe.
Otsego. Do you request a Zoom appearance for her?
Yes, if we could have a Zoom appearance on the 17th, that would be great. I think that she would understand that she'd have to be here in person for any future sentencings.
Okay, Ms. Goodrich, any objection to that?
No objection.
Okay, Ms. Price, I'm going to authorize Zoom appearances for March 17th at 10:40 a.m., but be in touch with your lawyer. Now that depends on, there being no bond problems. And I guess I do want to advise, I do see one test that was positive for THC. I want you to talk with Mr. Nightingale about that, about whether you've got any medical card for that or not. And if not, you cannot be using marijuana on bond, all right?
Yes, Your
So-
Honor. I just want to state I do have my medical marijuana card and I did submit it to the court about 2 months ago, but I
Okay,
can
that-
still
that maybe
touch
didn't,
base.
yeah, that maybe didn't come up through the bind over process. So make sure that you get Mr. Nightingale a copy of that so you can get it to the circuit court, okay?
Okay, Your Honor.
All right, anything further from the defense?
No, Your Honor, thank
From
you.
the people?
No, yeah.
All right, you're all set, Ms. Price.
Thank you.
And then bring Dan's out. Okay, we could call People v. Sinessa Escobar for sentencing. File 25-7046 FH. Counsel, you want to state your occurrences, please?
Melissa Goodrich, Flint County Prosecutor.
No, and again, Ms. Escobar, who appears in person tomorrow.
All right, and if you had a chance to review the pre-sentence report and recommendation?
Have your honor. Finding no errors or omissions, the scoring appears to be correct. And we are prepared to go forward to sentencing today.
Okay, and Ms. Goodrich, advisory guidelines were at 2-21. Any scoring challenges or objections to the report from the people?
No, Your Honor.
Okay, give me a chance here to review these. Council did advise me in chambers there'd be a couple letters of support. Give me a chance to peruse those for a second. I think you had a chance to review those letters of support from family and also documenting her involvement in treatment and NA programming. Mr. Nightingale, anything you want to say on your client's behalf?
Yes, Your Honor, thank you. So Ms. Escobar comes before the court for sentencing today. She's 25 years old. She is a mother to a young child. Since her release from jail, I think, both the court and the prosecutor have been sort of waiting to see how she did out of custody. I'm really happy to say that she's done very well. She has not only gained employment, She's back living with family. She's got obviously good family support based on the letters that the court's seen today. She's back and involved in her mental health treatment. She's medication compliant. She's doing, I think, everything that she needs to be doing to be successful going forward. I did not represent her at her last hearing in front of, the last matter that she had in front of the court. But I did just happen to be present in the courtroom when she was sentenced on that probation violation. And I specifically remember what this court said to her at that time, that she had no accountability, and the court didn't believe anything that she was saying that day. And I think if she decided to make a statement today, I think the court would have a different impression of her as she sits today than the court did, whatever that was last year before she was sentenced on that probation violation. She obviously did pick up this case after that violation when she was remanded into jail. She has accepted accountability for this. She has resolved this by a plea. She's obviously saved the court's time and resources as far as demanding or requiring her rights to a jury trial here. She wants to be accountable, and I think that's a different Miss Escobar than what the court saw when the court happened to be sitting in district court during the remodel here. So I'm hoping that the court is not going to sentence her to any additional jail time. As I've said, she is working, she's being productive. She does live downstate. The court ordered her to be here in person today, and she is here, Johnny on the spot. She was early. She's made great contact with counsel as this case proceeded. I could not have asked her to do more once she got released from custody. And so I hope that the court is going to let her do this probation sentence. I think she's going to be successful as long as she keeps doing what she's doing. And I just want to say on record, I'm really proud of her. So thank you, Judge.
All right, thank you, Mr. Nightingale. Ms. Escobar, you don't have to say anything today, but you're welcome to. Is there anything you want to say or no?
I'll keep it short, because last time I got a sentence, I was most definitely, I didn't take accountability. I hated to take accountability. I told my therapist that I lied. Like, it was a normal thing for me to lie. Like, I was on drugs so bad that I think for the first time in 6 years, I've actually been sober. Like, by next month will be my 1 month, like 1 year clean. It's different. Like, it's ever since, I don't know, like, I tell my mom all the time, like, those 6 months I did, like, I needed that. But it's weird because, like, I've OD'd many times and it wasn't enough for me to get clean. But when I was in there, what you said stuck with me too. You got, that day last time you sentenced me on a probation violation, like, it stuck with me. And I'm just doing the best I can now. And I'm proud of myself. And I take accountability for everything. I steal cases, the case I got now and everything.
Okay. Thank you. Ms. Goodrich, any recommendations from the people?
Yes, thank you. Ms. Escobar is 25 years old with 4 felonies and no misdemeanors. She is employed with a high school diploma. I would ask the court to order probation for her. I think that since her release from jail, she seems to have changed, especially from her first go around with all the unsuccessful discharges from probation, that she has hopefully seen the light and a better path moving forward. Thank you.
All right, thank you. Ms. Escobar, if you please stand for the court sentence. Ms. Escobar, you're here because last time I had you on a case, you were a probationer who was not doing well on probation and really did have lots of excuses for that. And then I revoked your probation and sentenced you to jail for 6 months. And I think you kind of knew and expected that could be a possibility. And so you brought with you some controlled substance medication you didn't think the jail would give you and smuggled it in. And so that's this charge. We did release you once you served that probation violation sentence. We did give you a bond in this case then to kind of see how you did. And I agree with what your attorney has said that, I mean, you've done some good things, okay, since you've been out in August. You're living with your family for support. You're working. You're attending support group meetings. You're attending therapy. You're maintaining your sobriety, and it sounds like you're proud of that, and you've got a lot to be proud of for that. Certainly in reviewing your pre-sentence report, you've had some challenges in your life, Some of those have been your own fault and some of them have not been your fault. But you know, you can only play the hand that you're dealt. And I hope at this point, you know, you're only what, 25 right now?
Yeah.
Okay, so I mean, you already got 4 felonies and you've already done a good bit of jail at, you know, by the time you're mid-20s. I hope that now you've gotten a taste of how a sober and a free life is. And it's better. So I hope you continue on that path. If you'd have told me back when this case happened that I would again be putting Miss Escobar on probation, I'd say no way. She's not going to be a good probationer. I'm hopeful at this point that maybe you'll be more compliant with probation. So I am going to place you on probation as recommended for an 18-month term. That's subject to the terms and conditions listed on pages 2 and 3 of the pre-sentence report. Those include you have to continue treatment and the NA meetings, support group meetings. You have to hold down that job. There's a crime victims assessment of $130, court costs of $350, state cost of $68, a monthly supervision fee to the Department of Corrections. The advisory guidelines are 2 to 21 months. So I hope you understand by now having 4 felonies already, these guidelines let me do a lot of things. Today, I'm going to place you on probation with no jail. These guidelines mean today I could send you to prison for 21 months and nobody would really bat an eye about that, okay? Because you've accumulated that record. So you want to maintain staying out of trouble. You go in front of a judge with felony case in the future, you know, you are likely to get jail or even prison. But at this point, I'm going to do a slight downward departure from that 2 months. I think Ms. Escobar has made significant progress while she's been on release, and I don't want to jeopardize that progress. Now, Ms. Escobar, if you are eligible to petition for discharge from probation early at the halfway point, if you've successfully completed all of its terms, we're going to hand you a piece of paper explaining that for you. Also, if you wanted to appeal from your conviction or my sentence or both, you could do so by filing an application for appeal. If you wanted a lawyer, I'd appoint one for you, but you'd have to ask me within 6 months. So we're going to hand you a piece of paper explaining those appeal rights and ask you to initial 1 copy for us. So we have a record we gave it to you. The other copy is for you to fill out if you want to take an appeal. Do you have any questions for me?
No.
Do you want Ms. Escobar to stick around to meet with probation office? Okay, so before you leave the courthouse, stop by probation and see what they got for you, okay?
Thank
All
you.
right, good luck. The call people be Jennifer Bird. It's 2 docket numbers.
Jennifer Bird, you stand accused of attempting to embezzle over $1,000 from a nonprofit. This court takes financial crimes seriously. Your plea has been accepted, but restitution and pre-sentence procedures are mandatory. Failure to comply with future legal obligations will not be tolerated.
All right, this is the time and date set for docket call. And I have a plea agreement in front of me and a second amended information in 7083. Mr. Nightingale, do you consent to the filing of the amended information?
We do.
And do you and your client waive its formal reading?
We do.
All right, Ms. Bird, would you please stand and raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can be seated. Watch out the chair doesn't spin on you. All right, Ms. Bird, a guilty plea hearing is an important event, so I want you to listen very carefully. You're waiving rights when you enter a plea that are very important. So if you have a question, go ahead and ask. We're happy to answer it. If you need a minute to talk to your lawyer, you just let us know. We're happy to give you that time. Do you understand that? Now, I have to advise you the maximum penalty that you could face for the charge that you're pleading to. And that would be in charge of attempted embezzlement of $1,000 or more. That is a felony crime. It is punishable by imprisonment in the state prison for not more than 5 years or in the county jail for not more than a year. Do you understand the maximum penalty that you could face for that charge?
Yes, I do.
Okay. Are you on probation or parole anywhere?
Yes.
Just this case? Okay. You didn't have any other cases pending at the time this happened?
No.
And did you read and understand the rights listed on the advice of rights form?
Yes.
Okay, and that lists the rights that you have to a jury trial, to be presumed innocent, have the prosecutor prove your guilt beyond a reasonable doubt, have witnesses against you appear to question them, to present witnesses in your own defense, have the court order them to appear, to testify in your own defense, or to remain silent and not have your silence used against you. You understand all those rights?
Yes.
Do you understand if you plead guilty, you won't have any of those rights? You're giving them up?
Yeah, we went.
Okay. And is that what you want to do?
Yes.
If I accept your plea, you give up any claim that it was caused by any threats or by any promises that aren't put on the record today. Do you understand that? I'm sorry, you have to say yes or no.
Yes.
Okay. Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission by filing an application. Now, the types of issues that you can raise on an appeal after a guilty plea are very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes.
All right, the plea agreement provides in exchange for your plea to the charge I outlined, the prosecutor will dismiss the original count 1 in that file, will dismiss the charges in file 7085 entirely, and there's restitution agreed upon of $53,824.06. And that's divided up in a manner specified in the written plea agreement between the Mullet Lake Area Preservation Society and the Sheboygan Area Chamber of Commerce. Do you understand the terms of that plea agreement? Mr. Nightingale, is that a full, fair, and accurate statement of terms?
It is.
Mr. Juliet?
Yes, it is.
All right, Ms. Byrd, other than that plea agreement, has anybody promised you anything else?
No.
Has anybody threatened you to make you plead guilty? Is it your own free choice to do so? Knowing all this, how do you wish to plead the charge of attempted embezzlement, $1,000 or more from a nonprofit?
Guilty.
Mr. Nightingale, would you perhaps assist with factual basis?
I can, Your Honor. So Ms. Byrd, between the dates of December 12th of 2024 and July 12th of 2025, you were in Sheboygan or living in Sheboygan at that time, right?
Correct.
And at that time, you were working as bookkeeping, essentially, right, for the Mullet Lake Area Preservation Society and for the Sheboygan Area Chamber of Commerce. And while you were in that capacity, working for the Mullet Lake Area Preservation Society, did you attempt to commit an act of embezzlement from that organization?
Yes.
And that you would admit the value is at least $1,000.
Yes.
And to be clear, you were an agent, servant, or employee of that organization, correct? And that organization is a nonprofit society, is that right?
Correct.
And no one gave you permission to use that money in that way, is that correct? And you basically took that money and out of that account from Mullet Lake as Area Preservation Society and converted it to your own account.
Correct.
I think that satisfies the factual judge.
Mr. Juliet, do you agree?
Yes, I do.
Mr. Nightingale, are you aware of any other promises, threats, or inducements?
No,
Do you believe I complied with the court rule?
the court has.
Mr. Juliet, do you agree with both those questions?
Yes, I do.
All right, well, Ms. Byrd, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea. We'll set sentencing for March 17th at 10:50 a.m. You'll have to cooperate with an interview to prepare a pre-sentence report for me so that the only thing I know about you right now is what I just learned. There's more to your story than that. So I learned that through the pre-sentence process and also through what your attorney shares and you share at sentencing. So before you leave the day, I want you to go to the probation office across the hall and say that you entered a plea and that you need to schedule an interview. Okay.
Stephanie Becker, repeated missed tests and failure to comply with bond conditions cannot continue. The court expects full communication and compliance with medical documentation. While temporarily released on personal recognizance, strict adherence to all orders is required, or the consequences will be immediate and severe.
Um, They're getting folks out from the jail for us, but we'll call first. People be Stephanie Becker. Is Ms. Becker present? This is file 25-7067 and 7068. FH, counsel, you want to state your appearances, please?
Melissa Goodrich, Lynn County Prosecutor.
No, and I get Ms. Becker appears in person to my right.
So we're here for a sentencing that's been adjourned a couple times, and then a show cause in both files that we had adjourned, where it was alleged that Ms. Becker was failing to test. And then we still weren't getting any testing results. And so I actually had signed a warrant for her arrest on January 26th for many missed calls and failing to test on several dates. So I guess I'd give counsel first an opportunity before we arraign on that, just to give me any updated information that you think might be pertinent to my decision about what to do with that.
Well, Your Honor, Ms. Becker's obviously here in person today. She was aware that this warrant was issued, has appeared today on her own volition. She does have, I think, on her phone quite a few medical records that we could provide the court regarding her current medical status. It's my understanding that she's still undergoing cancer treatment. She has finished, I believe, her radiation at this point. But she does have the port that's been installed in which she's getting essentially weekly infusions. She's doing all kinds of testing as well through her doctor. I'm hoping the court will leave her out of custody today, recall the warrants. We do need to withdraw her plea that was tendered October 21st, maybe is when we tendered that. It could have been later. But nonetheless, I do think that we are going to be able to work this out. I did get a revised offer this morning that I need to talk to Ms. Becker about. Perhaps if we set her back to this afternoon or something, we can maybe work this out and come back with a.
I have a docket next week on February 10th, and you've got Enoch for sentencing that day.
I think that we should do that. Try to come back next week and resolve this.
Okay.
Ms. Goodrich, do you have any additional information?
I don't have any additional information to know if the doctor's appointments were every day, so she couldn't test, or what has been happening.
All right, well, here's what we'll do. We're scheduled for sentencing, but there was a recommendation for 7411 in both files, and on review of the statute, and I advised counsel at a hearing last time when Ms. Becker wasn't here that I didn't believe that I could lawfully give the 7411 in more than one charge. So therefore, the sentence agreement can't be followed, and Ms. Becker be entitled to withdraw her plea. And you have no objection to that, Ms. Goodrich?
No objection.
Okay, so we're going to enter a withdrawal of the plea. We go back into a pretrial posture. And Ms. Becker, it's alleged that you are in contempt of court for failing to call the drug line and failing to submit to drug testing. You have the right to have a hearing on those allegations where they would need to be proven beyond a reasonable doubt. If you are found to be in contempt, or I believe that you're not following the conditions of your bond, I can revoke that bond. I can give you 93 days jail or $7,500 or both. Do you understand those maximum penalties? And we'll enter a plea of not guilty to the contempts, Mr. Nightingale, I presume. Okay. What I'll do is she's presented part of why I signed the warrant too, Ms. Becker, is we weren't seeing you showing up to court and we didn't know why. And I was told that you've got serious health issues going on. And so we were reluctant to take you into custody or issue a warrant. But then I just wasn't getting any detailed information about that. So that's why I did the warrant. You're here today. So I'm going to treat this as I'm not going to recall the warrant, but I'm going to treat this as the execution of the warrant and the arraignment on the warrant. And, and I'll allow Ms. Becker to be released on that on a personal recognizance bond, $500 personal recognizance. But here's the deal, Ms. Becker. I don't understand, and I don't need you to tell me right now, we're broadcasting on YouTube, many details about your health situation. But you need to be communicating that in detail to Mr. Nightingale so that we can know what's going on with you. There's no reason you shouldn't be able to call the bond line. And if you have to test, then you either need to test or have some medical documentation that you were, say, in a hospital that day and couldn't or something, right? And I think you being here today is progress. So, but what I am going to do is continue both of these cases for a docket call and a status conference on the pending contempts. Next, a week from today, February 10th at 10:30 in the morning. And I expect to see you here in person in the courtroom again. And Ms. Becker, you need to be calling that bond line.
Yes, Your Honor.
And testing as ordered. Okay.
Yeah.
Anything further from the people?
No, Your Honor, thank you.
Anything further from the defense?
No, Your Honor, thank you.
Okay, I'll see you next Tuesday at 10:30 in the morning.
Thank you so much, Your Honor.
Thank you, Judge.
I've got one on Zoom. Let me bring in Mr. Olowski. I want to ring him.
Dave Zinci, your actions constitute attempted criminal sexual
Morning, Mr.
conduct with a
Keogh.
minor. Despite
Good
mental
morning, Your
health
Honor.
struggles, the law requires
We've got
accountability.
Mr. Olowski
You have served
zooming in, I believe.
312 days and must register as a sex offender. This court emphasizes responsibility and
I am here.
rehabilitation while protecting the community.
Can you turn